General, if I could move to the merits. Let's say that I disagree with you on standing and on the remedies, and I have to reach the merits. And when we get to the merits, I think shall means shall. Then we're in a position where, as you see it, Congress has passed a law that it is impossible for the executive to comply with. Now, it's our job to say what the law is, not whether or not it can be possibly implemented or whether there are difficulties there. And I don't think we should change that responsibility just because Congress and the executive can't agree on something that's possible to address this problem. I don't think we should let them off the hook. So shouldn't we just say what we think the law is, even if we think shall means shall, and then leave it for them to sort that out?
Well, Mr. Chief Justice, let me take a stab at trying to persuade you that these considerations of resource constraints do properly inform the task for this court, which is to interpret the meaning of shall and the statute itself. And the first
Well, it seems to me that you're arguing with one of the predicates to my question, that I think anyway, shall means shall. What do we do in that situation?
If this court were to actually adopt that interpretation of the statute, then I think that it would be incredibly destabilizing on the ground.
Yeah, I didn't ask you what it would be. I want you to know what we should do. Should we still fulfill our responsibility to say what the law is, and then it's up to Congress and the executive to figure out a way to comply with that?
I think if the court did that, and the reason I'm turning to the practical implications here is because in the meantime, while Congress and the executive tried to figure it out, it would absolutely scramble immigration enforcement efforts on the ground. It would mean that DHS, I think, if it were under this kind of judicially enforceable obligation to treat each of those shalls as a mandatory shall.
So you're still arguing, I'm sorry, you're still arguing that that would be wrong to say shall means shall.
I think it would be wrong to say the shall means shall, and I would welcome the chance to explain as a matter of statutory interpretation why that's so. But at the very least, I don't think the court should announce it as a judicially cognizable injury here that could justify interference by the courts in light of the practical ramifications. And they're really two sides of the same coin, because I think one of the reasons the court has recognized that there is enforcement discretion in this area is precisely because of the practical necessity that agencies cannot proceed against every violation of the statute. That's what the court said in Heckler. Or in Town of Castle Rock, the court emphasized that an arrest mandate, if it were truly a mandatory judicially enforceable duty, would be a duty of entirely uncertain scope and priority and duration. It would be impossible to comply with it. And the court said that these background principles of enforcement discretion are a practical necessity.